I welcome each one of you to our AOR Aspirants Academy. This is our 17th lecture series. The topic for today is scope of interference of Supreme Court under Article 136 of Constitution of India. So I request every one of you to recite preamble along with me with a vision and with a mission that our goal is to achieve those whatever stated in the preamble, right? So preamble is a unity, preamble our identity, preamble our breath, preamble our health, preamble our sentiment, preamble our commitment, preamble our goal, preamble our soul, preamble our dignity, preamble our divinity. That is the reason I request everyone to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let us move on to the topic for today. The topic for today is, what is the scope of the Honorable Supreme Court to interfere or to exercise under Article 136 of the Constitution of India. So when the Honorable Supreme Court can entertain special leave petitions under Article 136. In other words, it will be helpful for our esteemed lawyers, advocates. What are the grounds under which SLP can be made? While preparing a special leave petition, whatever the grounds that you make, if it is an effective ground, then the Honorable Supreme Court will interfere and pass orders. So what are the possible grounds that we can make while drafting special leave petition? So before going into the illustrations when the Supreme Court can interfere, let us see first Article 136. Notwithstanding anything contained in its chapter, the Supreme Court may, in its discretion, grant special leave to appeal against any judgment, degree, determination, sentence, or order passed by any court or tribunal in any cause or matter pending within the territory of India. So here they have given wide power to the Honorable Supreme Court, because it is not a matter of right, dear friends, it is a matter of discretion vested with the Supreme Court. That is why they have said the Supreme Court may, in its discretion, grant leave to appeal against what? Against maybe judgment also, degree also, any determination, order, sentence. Order means it is not a final order. It may be interim order also. Order may be a final order or an interim order. So passed by any court or tribunal. Passed by any court or tribunal. So it is not a high court. Generally, generally the civil appeals come from the High Court to the Supreme Court. But in this case, under Article 136, passed by any order by any court, thereby meaning thereby, order means it may be a final order, it may be an interim order. Passed by any court means it may be any court or tribunal, maybe a district court or a high court. So such a power is vested with the Honorable Supreme Court to entertain the special leave petitions. But there is only one exception is there, that is there in Article 136 clause 2. Article 136 clause 2 says that it is not applicable to the law where it is applicable to armed forces, where there is any judgment, order, determination passed by tribunal which is related with armed forces, then that cannot be appealed to the Supreme Court by way of SLP. So this is what Article 136 clause 1 and clause 2 says, dear friends. Now we will be dealing with illustrations one by one. There are 5 illustrations we have taken. Let us see how the time permits to finish those grounds or the illustrations. Firstly, absence of speaking order. Let me give you 5 illustrations, then I will deal in detail. Because reason is we cannot list out all the illustrations under what possible circumstances the Supreme Court will interfere. It differs from case to case. But generally, we have taken few illustrations to show under what circumstances the Supreme Court will interfere. Number 1, absence of speaking order. Absence of speaking order, meaning thereby, when any court or high court, when they pass an order without reasons, it is a non-speaking order. So when order is passed, when that order is challenged before the court of law on the ground that it is not a order with justified reasons, or there is no reason given by the in the order, so therefore that becomes a ground to file SLP also, and even the Honorable Supreme Court have interfered and given relief when the order, impugned order, was a non-speaking order. This is first illustration. Secondly, when Supreme Court will interfere with the findings of fact. General practice is when there is a substantial question of law, the Honorable Supreme Court interferes to lay down a law for the rest of the country or to settle the law. Therefore, the other high courts and the other courts can follow, and it is binding effect under Article 141 of the Constitution. That is a general practice. But what are the circumstances under which the Honorable Supreme Court may interfere with the findings of fact? That is the second ground. Third is when Supreme Court will interfere with the exercise of discretion of the courts below. That is in the matter of sentence or fine. So third, I repeat, when Supreme Court will interfere with the exercise of discretion exercised by the courts below. General practice is the Honorable Supreme Court will not exercise its discretion when discretion was already exercised by the courts below, that is Sessions Court, thereafter High Court. When they impose a sentence, for example, there may be some offence where the discretionary power vested with the court to grant up to 10 years. The sentence may be up to 10 years. If that is the IPC section says, the Honorable High Court has given 7 years of imprisonment because they have the power to grant up to 10 years. So 7 years was given. Now, aggrieved party comes before the Supreme Court. Generally, the Supreme Court will not interfere with the discretion exercised by the court in matters of fine or sentence. But Now what we are going to study is even under that situation, under that circumstances, when Supreme Court can interfere. This is the third. Fourth point is when Supreme Court can interfere with the interlocutory orders under Article 136. So when Supreme Court can interfere with the interlocutory orders. Number 5, interference under Article 136 where mixed question of law and facts are involved. Where mixed question of law and facts are involved. So these are the 5 different illustrations by which we can understand that Supreme Court can interfere under these exceptional circumstances also. Hope it is clear, dear friends, the 5 points. Now let us deal with each point in detail. And this is very important topic, especially petition, even for AOR examination also, as well as for everyday practice also. It will help us in a very effective manner. Now moving on to the first heading, that is absence of speaking order. What are we going to deal with this? Let me read, dear friends. The scope and extent of the jurisdiction of the Supreme Court has already been discussed. Since the court has a wide discretion under Article 136, it is difficult to elaborate all grounds for interference. A few of the grounds on which the Supreme Court may interfere with the orders of the court below are explained hereunder. So what is the first illustration? That is absence of speaking order. So for this, I would like to refer one case law, therefore we can understand the essence. The name of the case is, please note down, dear friends, Messrs. Woolcombers of India Limited, Woolcombers of India Limited versus Woolcombers Workers Union and another. It is reported in 1974, Volume 3 Supreme Court Cases, page number 318. I repeat, it is reported in 1974, Volume 3 Supreme Court Cases, page number 318. The honorable judges who has delivered this judgment is, it is a division bench, Honorable Justice P. Jagan Mohan Reddy and Honorable Justice S.N. Dwivedi. These are the 2 honorable judges who has delivered this judgment. So what is the issue? Let us understand. So from the cause title itself we can understand it is a dispute between a company and the workman. So the appellant company challenged the award. The appellant company who is before the Honorable Supreme Court has challenged the award passed by the Industrial Tribunal, by which the rates of basic wages were fixed and they were granted an increment of ₹10 in their basic wages, and the scheme of dearness allowance was modified and linked to the cost of living index number. They have increased certain increment towards their basic wages. The tribunal did not give any reason. This is very important for the discussion point. The tribunal did not give any reason in support of the finding. The appellant company filed a special leave to appeal to Supreme Court against the decision of the Industrial Tribunal. Here there is a problem between the company and the workman. The matter was referred to the Industrial Tribunal. Industrial Tribunal has given a relief to the workman by increasing basic wages and dearness allowance without giving any reasons. Now who is aggrieved? Company is aggrieved because company has to pay. So therefore they do not want to pay. So they preferred special leave petition challenging the award. So the court will definitely ask, what is the challenge? How are you aggrieved out of the award passed by the tribunal? His contention, the company's contention is the industrial tribunal award is not supported by any reasons. So therefore, absence of speaking order is a ground for interference. Therefore, they have challenged only on that sole ground. There are not multiple grounds. But now the Honorable Supreme Court, what did they held? When a judicial or quasi-judicial authority comes to a finding, it is expected to give reasons in support of the same. When the industrial tribunal is increasing the dearness allowance or basic wages, it must be supported with reasons. It must be supported with supporting documents, whatever the finding is. So must be supported with reasons which is calculated to prevent. Why reasons has to be there? This is very important, dear friends. Why reasons has to be given? They say to prevent arbitrariness in reaching the conclusion. So it will prevent the arbitrariness to reach the conclusion. This also applies to the fixation of minimum wages. Now let me take you to para 5. They have explained why every order must be supported with reasons. They are given step by step, dear friends. Once you understand this concept, then you will always, when you are challenging any order, you will try to see whether it is a speaking order or not. The reason is the giving of reasons in support of their conclusions by judicial and quasi-judicial authorities when exercising initial jurisdiction is essential for various reasons. When it is a speaking order, it is very important. Why? First reason is it is calculated to prevent unconscious unfairness or arbitrariness in reaching the conclusions. So it will prevent the arbitrariness. If I want to give relief, if a court wants to give relief to A, not to B, so if they are going to give reasons, then they cannot grant relief to A. So therefore, this will prevent unconscious unfairness or arbitrariness in reaching the conclusions. This is very important. Next, the very search for reasons will put the authority on the alert. The authority who is passing an order, he will be very alert. It will put the authority on the alert and minimize the chances of unconscious infiltration of personal bias. So when the authority is going to give reasons, then it will automatically prevent arbitrariness, personal bias or unfairness in the conclusion. The authority will adduce reasons which will be regarded as fair and legitimate by a reasonable man and will discard irrelevant or extraneous considerations. So therefore, dear friends, it will prevent the arbitrariness, it will prevent the bias, and when it is supported by the reasons. Second, it is a well-known principle that justice should not only be done but also appear to be done. Unreasoned conclusions. Now how they have beautifully worded. Unreasoned conclusions may be just, but they may not appear to be just to those who read them. It may be a justified order, but when it is not supported by reasons, a reader will understand this is not worth reading, or there is something why the order is given, maybe based on bias or arbitrariness when it is not supported by reasons. So unreasoned conclusions may be just, but they may not appear to be just to those who read them. Reasoned conclusions, on the other hand, will have also the appearance of justice. Third reason they are giving, it should be remembered that an appeal generally lies from the decision of the judicial and quasi-judicial authorities to this court by special leave granted under Article 136. A judgment which does not disclose the reasons will be of little assistance to this court, that is Honorable Supreme Court. When High Court order is not supported with any reasons, thereafter what will happen? When you are challenging before the court, it will be of little assistance to the Honorable Supreme Court when order is not supported with any reasons. A judgment which does not disclose the reasons will be of little assistance to the court. The court will have to wade through the entire record and find for itself whether the decision in appeal is right or wrong. In many cases, this investment of time and industry will be saved if reasons are given in support of the conclusions. So it is necessary to emphasize that judicial and quasi-judicial authorities should always give the reasons in support of their conclusions. So dear friends, the Honorable Supreme Court has explained very beautifully in this judgment what is the reason that High Court order, any order, be it any order, should be supported with reasons. Firstly, they say when you are sitting as an authority, when you are supposed to give reasons to your conclusion, if you need to give reasons, that will prevent arbitrariness, that will prevent bias, that will even add a common reader to understand whether it is a reasoned order. Even a party may lose his case, but when he reads the entire judgment, he will also get satisfaction that yes, though we have lost the case, but the Honorable Court has given the entire findings, have appreciated the entire evidence, and has given a right conclusion. Though a losing party will certify that this is a justified order because they have elaborately discussed about our case. And moreover, justice should not only be done but also appear to be done. That is the reason, dear friends, why judges are supposed to sit on the dais, and why there is a distance between the judges dais and the advocates where we stand, and they are like this: Almighty, my lords. When I say my lords, when I attended a lecture given by one of the former judges of the Supreme Court, Justice Ravindran, my lord, he has told the audience that you should not fight with three lords. You should not fight with three lords. First lord is the Almighty, who believe that who is the creator, who has created us. So you should not fight with him. Second, my lord, is judges. My lords are always right, so you should not fight with the judges. Third lord is landlord, where we reside. So you should not fight with the landlord, you will be out of home. So these three lords, you should never fight, you should always be submissive to them. Still I remember the lordship's words, golden words. So after giving the reasons for this award, how an award has to be, how an order has to be, ultimately what has happened in this case? At para 18 of the judgment, dear friends, the Honorable Supreme Court has directed the tribunal to record a fresh finding on the quantum of the basic wages and dearness allowance by applying the region part of the industry cum region formula, and in the light of our judgment, parties are allowed to adduce their evidence on this limited question only. Matter has been remitted back. The tribunal should send its findings to this court within 4 months from the receipt of the record from this order. Cost will abide the event. So therefore, dear friends, since the award was not supported by any reasons, matter was sent again back to the tribunal to consider on certain issues and submit a report within 4 weeks or 4 months, I am sorry, to the Honorable Supreme Court. So therefore, from this case, what we have learnt is every order must be a speaking order, must be supported with reasons. If there is no justified reason, you can ask that it is a non-speaking order. Therefore, you can seek the interference of the Honorable Supreme Court in SLP's consent. Hope it is clear. Now, there is yet another case. This is also on non-speaking order in criminal cases. Rama and others. The second case, I am moving on to the second case, non-speaking order. Rama and others, appellants versus State of Rajasthan. It is reported in AIR 2002, Supreme Court 1814, page number 1814. AIR 2002, Supreme Court 1814. So what is this case about? This is, I'll give you a brief background, dear friends. It's just only one page judgment. A criminal procedure code section 378. It is an appeal against conviction. Disposal of, by simply saying, the Honorable High Court has simply disposed of the appeal by saying it's appeal against conviction. So disposal of, by simply saying that there is no error apparent in the finding of the trial court without reappraising evidence, not a proper method. Here the Honorable High Court has given just a finding that I carefully gone through the trial court order and reappreciated the entire evidence. I do not find any error in the trial court order, therefore I uphold the conviction. That's all, just 2 paragraphs. Whether is it sufficient or not, that is a challenge before the Honorable Supreme Court. Now what did the Honorable Supreme Court held in this case? I will read it. In a criminal appeal, a duty is enjoined upon the appellate court. Who is the appellate court here? The Honorable High Court. Appellate High Court to reappraise the evidence itself, and it cannot proceed to dispose of the appeal upon appraisal of evidence by the trial court alone, especially when the appeal has been already admitted and placed for final hearing. Upholding such a procedure would amount to negation of a valuable right of appeal of an accused, which cannot be permitted under law. It is a novel method, the Honorable Supreme Court saying, commenting upon the High Court orders by saying, it is a novel method of disposal of criminal appeal against conviction by simply saying that after reappreciation of the evidence and re-scrutiny of the records, the court did not find any error apparent in the finding of the trial court, even without reappraising the evidence. Such procedure adopted by the High Court is unknown to law, matter remitted to High Court. So when there is a conviction by the Sessions Court, when an aggrieved accused comes before the High Court admitted it, and when there is a final hearing, they upheld the conviction order by holding, I have gone through everything, nothing wrong in the trial court, therefore I confirm the conviction, without referring to any PW1, PW2 or doctor's evidence, nothing. So can we do like this? The answer is no. The Honorable Supreme Court has said that this is not a good method at all, and you are talking about this case involves the liberty of an individual, so it cannot be disposed of by just in 2 paragraphs and without appreciating the evidence in entirety. Here the High Court has acted as an appellate court, so it has failed in its duty. Therefore the Honorable Supreme Court has remitted the matter to the High Court for fresh adjudication. So this is a second order, dear friends. Now moving on to the next heading, that is interference with findings of fact. So we have successfully completed the first heading, where the Supreme Court will interfere where there is an order without any reasons. Now moving on to the next heading, that is interference with findings of fact. Generally we were taught that the Honorable Supreme Court will not interfere with the facts. Only on the question of law that Honorable Supreme Court will interfere. But then what is the exceptional situations or circumstances where they can interfere with the facts? So There is a case law, dear friends, Nihar Singh versus State of Punjab. Nihar Singh, Nihar, Nihar Singh versus State of Punjab. It is reported in 1964, Volume 4 SCR, page 5. 1964, Volume 4 SCR, page 5. In this case, I am not going to read the entire case for you. The essence, under what circumstances the Supreme Court will interfere with the findings. Firstly, when the finding is such that it shocks the conscience of the court. When the Honorable High Court has given some finding, when that order is challenged, it must shock the conscience of the court. What sort of order is this? So it must shock the conscience of the court, number one. Or the Honorable High Court or any court have disregarded the forms of the legal process. So when there is a established procedure of law that was given go by, they have not followed it. That is the second point. Third point, some violation of the principles of natural justice. When you are not heard, when the authority is biased, thereafter you came to know. So therefore, when there is a violation of the principles of natural justice, the Honorable Supreme Court will interfere with the findings of the fact also. And the last point is, when there is a substantial and grave injustice has been done. So these are the grounds under which the Honorable Supreme Court will interfere even with the findings of the facts. For this, let me refer one case law, dear friends. I have taken this case for two purposes, because this name of the case starts with my name, therefore it is easy to remember. Saravana Bhavan versus State of Madras. Saravana Bhavan versus State of Madras. AAR 1966, Supreme Court 1273, page number 1273. It is Saravana Bhavan and Govindaswamy. AAR 1966, Supreme Court, page number 1273. So the name of the case is Saravana Bhavan and Govindaswamy versus State of Madras. So when we took this case, we came to know that it was a constitution bench judgment comprising of Honorable Justice Gajendra Katkar, Chief Justice, K.N. Vanchu, Honorable Justice M. Hidayatullah, Honorable Justice V. Ramaswamy, and Honorable Justice P. Satyanarayana Raju. So what is this case about? The case is all about the two appellants, dear friends. The two appellants had been convicted under section 302, read with 34, and 449 of IPC, and were sentenced to death. So they were sentenced to death as they were found guilty of murders of 3 persons. These 3 persons have found guilty of murdering 3 persons. The sentence was confirmed by the High Court also. The sentence was confirmed by the High Court. The main evidence against the accused was that of an approver. So the approver has given a statement against their own colleagues or their own co-accused. Based on the approver statement, they were convicted. The Supreme Court was invited under Article 136 to reverse the concurrent finding on the ground that the approver's testimony was incredible and that there was neither general corroboration of testimony of the approver nor corroboration in respect of either of the appellants. So when there is an approver's statement, it is not supported by anything. So when there is not supported by anything, so whether his statement become reliable, and whether based on solely on his approval statement, whether these people can be convicted. The Honorable Supreme Court in majority, they have said, in an appeal by special leave under Article 136 of Constitution of India, the principles for the exercise of jurisdiction in criminal cases which the Supreme Court will ordinarily follow are as follows. So when the Supreme Court will interfere, the court will not reassess the evidence at large, particularly when it has been concurrently accepted by the High Court and the court or courts below. So when the Sessions Court has given a finding, when it is affirmed by the High Court, generally the Honorable Supreme Court will not interfere at all because concurrent findings. But when they will interfere, therefore the court interferes, something more must be shown, such as now scope for interference. They are narrating that there has been in the trial a violation of the principles of natural justice. Similarly, what we have seen in the non-speaking order, violation of the principles of natural justice, here also violation of the principles of natural justice or deprivation of the rights of the accused or a misreading of vital evidence or an improper reception or rejection of evidence. This is most important. Improper reception or rejection. Improper reception in the sense when such evidence is immaterial, but you consider it. This is what perversity is. Generally, in the Honorable Supreme Court, when we argue a case under Article 136, they ask what is perversity. Perversity means it is improper reception of evidence, where certain documents or vital documents, irrelevant documents are taken into consideration, and relevant documents or evidence not considered at all, where they are supposed to consider not considered, where they need not consider at all but they have considered. So improper reception or rejection of vital evidence or a misreading also. So based on this, dear friends, they have narrated beautifully that therefore before this court, I repeat, interferes something more must be shown, such as that there has been in trial a violation of the principles of natural justice or a deprivation of the rights of the accused or a misreading of vital evidence or an improper reception or rejection of evidence which discarded or received would leave the conviction unsupportable, or that the court or courts have committed an error of the law or of the forms of legal process or procedure by which justice itself failed. This is very important. So because of these actions, for example, improper reception or rejection, violation of the principles of natural justice, or misreading of the vital documents or evidence, resulting in miscarriage of justice where justice is itself failed. In such a scenario, the Honorable Supreme Court will interfere in criminal matters. And there is one more case, dear friends, on the same similar lines. Name of the case is too long. Barvada, Bohin Boy, Hirji Boy versus State of Gujarat. I say the, yes, 1983, it is reported in 1983, Volume 3 Supreme Court cases, 1983, Volume 3 Supreme Court cases, page number 217. Barvada, BHARWADA, Barvada, Bohin Boy, Hirji Boy versus State of Gujarat. You can see from the citation, dear friends. Now, the most important aspect why I cited this case is because they have summarized, the Honorable Supreme Court has summarized the principles. The court summarized the circumstances when concurrent findings of the courts below in a criminal matter can be reopened by the Supreme Court in an appeal under Article 136 of the Constitution. In this case, they have given 4 points, dear friends. Number 1, that the finding is based on no evidence. So you convict a person based on no evidence. So that is a ground for SLP, that a finding is based on no evidence. Number 2, that the finding is perverse. Once there is a term perverse, we have understood it is improper reception or rejection of the evidence. So that the finding is perverse, it being such as no reasonable person could have arrived at, even if the evidence was taken at its face value. Number 3, the finding is based and built on inadmissible evidence, which evidence, if excluded from vision, would negate the prosecution case or substantially discredit or impair it. This is the third ground. What is the fourth ground? Some vital piece of evidence which would tilt the balance in favor of the convict has been overlooked. I repeat, some vital piece of evidence which would tilt the balance in favor of the convict has been overlooked, disregarded, or wrongly discarded, and punishing the convict, punishing the accused. So based on these grounds, meaning thereby, ultimately what the Honorable Supreme Court has held is, when you are conducting a trial or when you are hearing an appeal, you must, as an appellate court, you must reappreciate all the evidences. You do not see merely that I have scrutinized the documents and then I find no wrong or mistakes on the part of the trial court, therefore I confirm the order. Don't do that. Then it becomes a stereotypical order. So what you need to do is, as an appellate court, you need to reappreciate the evidence and you have to discuss each vital evidence and you have to give reasons for reaching the conclusion. Therefore, a common litigant will also understand. Even it will be of greater assistance to the Honorable Supreme Court when it is challenged. Otherwise, it is of no use. So, under these circumstances, absence of speaking order and then interference with respect to the concurrent findings of the facts in criminal matters, where the Honorable Supreme Court can interfere. Now it is almost 4:30, dear friends. We generally conclude within an hour. There are remaining illustrations also. So we will conclude in the coming session. So let me sum up just in few lines. Today what we have seen is Article 136 of the Constitution of India. In the earlier lecture, we have discussed about the wide power of the Honorable Supreme Court. The topic is an introduction to special leave petition. Now we are discussing about the scope of interference of the Honorable Supreme Court under Article 136, in which the first illustration is absence of speaking order. Every order must be supported with reasons, because the reason is very, very important, because once we start giving the reasons, that will prevent the arbitrariness, bias, and then it will not only justice be done but also appears to be done. Even a losing party can satisfy himself, yes, we have placed all the points, that is all considered, and then the Honorable Judge has taken this decision. Even that order is being challenged before the appellate court or before the Supreme Court, it will be of assistance, greater assistance for the Honorable Supreme Court to test the correctness of the order. That is the most important aspect. Second is interference with the findings of fact in criminal matters. Generally, in the facts, the Honorable Supreme Court will not interfere. They will interfere only when there is a substantial question of law. What is substantial question of law? When there is a grey area with respect to the interpretation of any statutes, where there are some unsettled principles, where the authoritative pronouncement from the apex court, when it is delivered, landmark judgment is delivered, the remaining courts in India can follow it. Otherwise, there will be conflicting decisions from various courts. So therefore, in such a scenario, the Honorable Supreme Court will interfere. But with respect to the findings, when the Honorable Supreme Court will interfere? When there is a grave injustice, substantial injustice has caused to the litigant, or when there is a gross violation of the principles of natural justice, when an order is passed without hearing the party. Punishing a person, you are imposing a sentence without hearing a party, this is a gross violation of principles of natural justice. Right? So, in these situations, the Honorable Supreme Court will interfere. So, with this, dear friends, in the coming sessions, we will be seeing the remaining portions where the Honorable Supreme Court will interfere. Before concluding the session, just I need your 1 minute attention. One of my students, interns, has done his internship for the last 2 months. Now today is his final day. In all your presence, I want to give this book to him as a token of love, respect and hard work. Yes, he is Mr. Tijil Pandey. Yes, from Lloyd Law College. This is a book earned by him through his hard work, sincerity, punctuality, and he has been one of the role model for other students. Thank you, Tijil. Yes, all the best. All the best. So